Yes, just a minute. If you're ready to continue, would you like to ask the usher to call Mr. Martin back in, please?
Yes, Mr. Chairman, thank you. May we please have Mr. Martin back in the hearing room? Thank you.
All right, Mr. Martin, you ready to carry on?
Yes, sir. I'm grateful for the longer break. I'm sorry for the inconvenience.
No, there's no great inconvenience. We'll just go on a bit longer, as I said earlier on, to make up the time, but I'm glad it was helpful. Right, when you're ready then, Mr. Millett, please.
Yes, thank you. Mr. Martin, I want to revisit something with you, if I may, that emerged from this morning. Can we please have back up on the screen Technical Guidance Note 18, which is at CEL 403725. Now, there it is. If we go, please, to page 2, option 1. I read it to you this morning, and I'm not going to read it to you again unless you'd like me to. But can I ask you this question? When you first saw option 1 as set out on the screen there, did you think that the BCA had interpreted ADB 12.7 as having that effect? In other words, restricting all elements of the cladding system, including external facing materials, to materials of limited combustibility? Or did you think that the BCA had deliberately tightened the material of limited combustibility restriction by way of departure from 12.7?
I think they've done it deliberately in your second of the two options.
Right.
I don't think I had any evidence of that. That's just what I assumed.
Right.
Perhaps I was wrong.
Okay. And can we take it that you never had a discussion with Steve Evans or Diane Marshall or John Lewis, for that matter, on that question, whether they thought that option 1 reflected ADB as it stood in the way you saw it, or whether they understood it your way but had chosen to make it tighter?
No, I haven't had that conversation.
No. Now then, that's helpful. Can we then go, please, to NHB 402792? What I'm showing you here now is an email chain from the middle of June 2015. Can we go, please, to page 4, at the foot of that page? And we can see there that at the, forgive me, we need to go to the top, I'm afraid, of, yes, what I want is the top of, middle of page 3, apologies. And here we have an email from Steve Evans to you, 15th of June 2015 at 15:35. And he says this, and I'm going to read this to you at some length, so bear with me. I write to request the department's view regarding the need for limited combustibility external cladding finishes on buildings with a floor level exceeding 18 metres in height, assessed in accordance with paragraph 12.7 of approved document B, together with the associated paragraphs 12.5 to 12.9. As I understand it, Section 12, paragraph 12.2, explains that there is a need to slow down the rate of fire spread across the external faces of the building. This is elaborated upon in paragraph 12.5, which states that the external envelope of a building should not provide a medium for fire spread if it is likely to be a risk to health and safety, and the use of combustible materials in the cladding system and extensive cavities may present a risk in tall buildings. I should say such a risk. Generally, a tall block of flats with the defend-in-place policy would be considered a high risk to health and safety. At this point, therefore, it is assumed that the entire wall build-up is at issue, and so the following parts of the external wall construction should not assist with fire spread. And then there are a number of bullet points set out, the first two of which are external cladding material and backing board if appropriate, and then insulation. And then after the bullet points, he continues. However, the wording of para 12.7 of ADB2 then goes on to state that in a building with a story 18 metres or more above ground level, any insulation product, filler material, not including gaskets, sealants and similar, etc., used in the external wall construction should be of limited combustibility, see Appendix A. This restriction does not apply to masonry cavity wall construction that complies with diagram 34 in section 9. Whilst this paragraph is clear that insulation products are a risk to fire spread, firstly, it is unclear as to the meaning of filler products, and secondly, it is unclear whether it is intended that these recommendations apply to the external cladding finishes. Use of the word etc. implies that the major components of the cladding system need to be considered. Whilst many cladding finishes fall within the Table 7, A7 guidance for materials of limited combustibility, we've come across a large number which do not, and so, even with a Class 0 surface spread of flame rating, and when used with a MOLC insulation, material of limited combustibility insulation, the objectives of Section 12 may still not be met, even though the guidance in paragraph 12.5 has been met. Now, just pausing there, if we can, in the email, I've read it all to you thus far, looking at the section of the email where he says, while this paragraph is clear, I think we need to turn back to page, the previous page, end of line 4. You see that?
Yeah.
Whilst this paragraph is clear. He then goes on to point out two aspects of 12.7 which are not clear, namely, 1, filler, and 2, whether the MOLC requirement in 12.7 of ADB applies to the external facing. Now, I think you would agree, wouldn't you, that this is not the first occasion on which the lack of clarity of this section of ADB 12.7 had been raised with you?
Correct.
Yes. Nor was it the first time that you'd been made aware that the intended meaning of filler material was unclear.
True.
Yes. Now, given the NHBC's position and status, as you've explained to us this morning, did it concern you at all that ADB did not appear to be clear to Mr. Evans in these two respects, despite what at least appears on its face to be careful consideration of its content by him?
I think, as I recall, the reason Mr. Evans had sent this message, bearing in mind this is after the BCA guidance note had been produced, was that I think NHBC were in dispute with a developer, I don't know who, and they wanted something that they could show the developer that they were correctly applying, that the BCA guidance note was the right approach. So I think they wanted something from me which supported what they were telling the developer. So it wasn't that he didn't understand it; he fully understood it, and that's why the BCA guidance note was written the way it was. But the developer was disputing that, and they were asking for something from me to try and help.
Well, first, how did you know that? How did you know the background? He doesn't refer to it in here.
I think I may have spoken to him.
Right. What, before he sent you this email, or before you responded to it, or what?
I can't remember the exact timing, but I think that's what happened.
Whether or not he was in a state of confusion, or whether or not a developer was in a state of confusion, were you not troubled to read the fact that there was a debate on this very topic, namely about the lack of clarity or scope of 12.7 and the need for all elements of the cladding system to be material of limited combustibility, given that, as you told us this morning, you thought that problem had been settled by the publication of BCA Technical Guidance Note 18 the previous summer?
I guess I was disappointed to some extent that they were still having these problems, yes.
Right, and you say you were disappointed. What did you learn? Why did you think that they were still having these problems?
I think it's the nature of working in building control, is that some developers are not particularly keen to do what the building control body thinks they should do.
Was it not rather that, in fact, although the BCA guidance had, as you told us, as you'd understood it, departed from 12.7, there were, at least in some quarters of the construction industry, developers who thought it was going too far, thought it wasn't required, and wanted to rely, as they thought they were entitled to, of course, on ADB as it stood.
Yeah, I was disappointed that was happening and wanted to do what I could to try and help NHBC.
Well, did it not occur to you that there were bound to be developers who would say to building control officers who had read the BCA guidance, well, that may all be very well, but that's not what ADB says, and I'm going to stick with ADB. And if you don't like it, I'll challenge you in court.
I suppose for me that's not an unusual experience for a building control body. Getting into a dispute with a developer is
No, but
it's not uncommon.
No, maybe. But the point I'm really putting to you is that there's now a divergence, isn't there? There's the statutory guidance out there, which means one thing, and there's the BCA guidance, which, as you understood it at the time, was a departure from the statutory guidance. Wasn't that a thoroughly undesirable situation?
It was clearly undesirable, yeah.
Yes, but it could only be for central government to cure that problem by bringing 12.7 in line with option 1 of Technical Guidance Note 18.
Which is what I wanted to do once we revised ADB.
Months, years down the line.
At the when is the date of this email? I think it's 2015, is it?
Yes, June 2015.
I thought I was about to start work on a review of ADB at that time, I think.
Let's go on with the message. If we go, please, to the final paragraph of this email. If we go, please, to page 4. He says this. And if you want to read any more of it, I'm happy to do that. I should just, to be fair to you, tell you, at the top of the screen, he identifies BS 9991, which says combustible materials should not be used in cladding systems and extensive cavities. And there's a citation from that that's set out, and then a reference to BR 135. And then in this paragraph, at the end, he says this, if we scroll down to the foot of page 4, our own view is that there is little point in ensuring that an insulation product meets with MOLC requirements, MOLC requirements, when it can then be faced with a cladding finish, which, whilst achieving a Class 0 surface spread of flame requirement, becomes a contributory factor in the spread of fire up the building when acted upon by a flame plume from a flashed-over fire. However, there appears to be a difference of interpretation across the industry, and so your opinion, steer, would be very welcome. Thank you for your time. Now, when you received this email, did you have any reason to doubt what Mr. Evans was telling you, namely that there was a difference in interpretation across the industry?
Well, my understanding is that they drafted this email deliberately to get something from me that would help them in the argument with a developer that they were dealing with. So what they're talking about in that last paragraph is showing a building control body giving consideration to the functional requirement, which is good practice for a building control body.
Well, let's be a bit more precise. When you saw this, did you think that Steve Evans was telling you the truth, that there was, or there appeared to be, a difference in interpretation across the industry?
Well, there'd definitely been one, and the BCA guidance note was trying to address that. And as I say, I think there'd been a disagreement. So a disagreement is a difference of interpretation, depending on how you want to consider it.
I mean, did you think that he was telling you the truth, that there was a difference in interpretation across the industry, as he says, or simply that there was a tricky developer out there who was being controversial, heterodox?
I'm not sure I thought about it in those terms at the time.
Well, let's taking it at face value then, and assuming that Mr. Evans was telling you the truth. On seeing that statement, did you not recall the assurance that you'd given Peter Holland back in the February of that year, 2015, that a fire like the torch fire in Dubai could not happen here without guarantees, of course, because of 12.7.
I said should not.
Should not. Quite right. Should not happen here, no guarantees, because of 12.7.
But this is the point that I was making in the email, is that there are no guarantees because people interpret the guidance differently, and you're relying on the building control system to try and address that.
No, you didn't. You didn't tell Mr. Holland, did you, that there was a difference in interpretation of 12.7 across the industry, did you? And that some people interpreted it as catching the core of an ACM panel and some people didn't.
No, I didn't tell him
No.
at the time, no.
And we've covered that.
Yes.
And can we take it that you didn't immediately realise that if Evans was right, and there was, as he says, a difference in interpretation across the industry, then the assurance that you'd given to Peter Holland was baseless, and that a repeat of the torch fire could certainly happen here?
I didn't think of it in those terms, but I can see the point you're making. I just saw this as an opportunity to help a building control body address a problem.
And when you saw this email, did you not have cause to reconsider the conclusion you'd reached in your worry list on the 29th of April, we saw earlier, which was that the issue of combustible cladding need not be included because it would have been adequately addressed by the BCA Technical Guidance Note 18?
I think, again, we've covered that already. My view is that at the first opportunity I was going to change approved document B to try and address that point.
The first opportunity being when?
The review of approved document B, which at this time I thought I was about to start.
The BCA's guidance note, as I think the history shows us, had been on the BCA's website from about mid-August 2014. Certainly that's when you'd seen it, yes?
Yes.
Yes. And yet here we have one of the individuals responsible for the drafting, the original drafting of the BCA guidance, namely Steve Evans, who oversaw, as we know, John Lewis's original drafting of it, still asking you about the meaning or intended application of the very sections of the approved document that the guidance was intended to deal with. Yes?
Yeah, I think he was doing it not because he didn't understand, because he wanted something from me to confirm it back to this problem developer.
Why did you ask him? Did you ask yourself? Why does this problem developer want something from me, Mr. Martin, as opposed to taking it on trust from Steve Evans?
I think it's one of the problems that occurs with building control bodies having to treat developers as clients, is that they find it difficult sometimes to deal with the arguments they have sometimes.
Did it? Yeah, I mean, I appreciate that, but given the context that you've placed upon the circumstances in which this email came to you, namely a difficult developer wanting your word for it, did it not occur to you that actually government had a very important part to play, because it was only government who could spell out with authority the intention behind its own statutory guidance, and not Mr. Evans?
That's kind of the problem with the system, I think.
No, Mr. Martin, it isn't. To be colloquial, the problem developer wanted it from the horse's mouth, and you were the horse. Did you not understand that?
Yes, and that's part of the problem.
And you say part of the problem. It was a problem of your making, because all you had to do was step up to the plate, act within the authority that you had, and provide an official government view or line or statement of the Secretary of State's intention, rather than leaving it to industry bodies, influential though they may have been, like the NHBC.
I think you assume I've had more freedom to do that than I had. I still felt that the Building Control Alliance guidance note was the the best approach to take at this time.
Did you consider that in this paragraph here that I've read to you, Mr. Evans had put his finger on an anomaly within approved document B that you hadn't addressed, namely that if 12.7 meant that all elements of the cladding system had to be MOLC, materials of limited combustibility, then how could it be faced with a panel, the surface of which only needed to achieve national class 0, surface spread of flame, or Euro class B, which by definition is not MOLC, not material of limited combustibility?
I guess that's the point that we'd been talking about. I didn't see that as a new issue.
Well, did you not wonder to yourself what a developer would do when confronted with option 1 and approved document B? Would it not be perfectly reasonable for the developer to say to the building control officer, well, you're requiring my external facings to be class A1 or A2 of limited combustibility, but it says here in diagram 40 that it only needs to be class 0 or class B. Did you think about that as an anomaly, as a problem that a building control officer using option 1 would face?
I think in the context of this message, what I was thinking of the principle as a class O surface, but used in isolation, there's the risk that something immediately below the surface might become a contributory factor. I think that's how I read this paragraph, and that's the point that we've been discussing already.
Well, when you read option 1 and understood that it was a departure, as you told us, from approved document B, a tightening up of approved document B, did you not also ask yourself or ask NHBC, well, if this is going to work, what is the reader, what is the developer, what is the building control officer to make of class 0? Or of diagram 40, of 12.6?
I think I took the view at the time when I was looking at the BCA guidance note, is it had been written by several building control practitioners, including some fire safety engineers from NHBC, and they'd concluded that was the best way to address the issue. They were looking at construction projects every day, which I wasn't. So they were using an approach which they felt would work in the industry that they were dealing with.
Did it not occur to you to ask even yourself the question, I'm really repeating the question, that if the BCA is going to insist, or building control officers are going to insist, that all elements, including the external facings, in an external wall build-up be of limited combustibility if following the linear route, they are going to be met with an obvious challenge, which is, that can't be right, I'm entitled to use class 0 or class B because diagram 40 and 12.6 say so. Did that not occur to you?
I'm not sure if it did. It certainly occurred to me the question of timber frame building and the fact that there would be situations where the designer might say to the building control body, look, this isn't allowing me to do something which I think should be allowed. And then that would put the building control body in a position where they can talk through the actual risks associated with the specific form of construction. So I saw that as being a good thing.
That involves devolving down beyond the department, down to the actual building control officer, not just what meets the functional requirement, but what constitutes the linear approach. It's all up in the air. It's all a matter of taste, judgment, assessment.
Well, compliance with building regulations is something that is judged by the building control body.
Yes, but following the linear route isn't, is it? The linear route is the linear route. It's a set of standards proven by scientific testing, which can be followed, which, if followed, presumptively allow you to satisfy the functional requirement.
And you'd still expect the building control body to be thinking about the functional requirement.
But not, as I suggest to you, not to fill in blanks.
I think to some extent that is the case, because building control officers get presented with forms of construction that didn't exist at the time we were writing the approved document. That's one of the problems you have with having a fixed document, if you like, is that construction practice changes and people come up with innovative approaches. So building control officers are regularly faced with that question.
Looking at the paragraph then, coming back to the point, what is the answer to Mr. Evans's question in the first sentence? Well, rather, their view, which is that there's little point in ensuring that an insulation product meets with MOLC requirements when it can then be faced with the cladding finish which, whilst achieving a Class 0 surface spread of flame requirement, becomes a contributory factor in the spread of fire up the building, etc.
Well, he's right, isn't he? It's fairly obvious.
Yeah, he's right. Did that not reveal to you that if option 1 of the BCA guidance was to be followed, there would be this anomaly?
Well, if they followed the BCA guidance, they'd be using entirely materials of limited combustibility, so there wouldn't be an anomaly.
There'd be an anomaly, wouldn't there, as between the BCA guidance approach on the one hand and what the statutory guidance required on the other?
Yes, so they'd need to consider whether it was appropriate to allow a particular cladding panel in the situation they were looking at.
And you mentioned timber frame cladding. What was your view?
I mentioned timber frame buildings, not timber frame cladding.
What was your view about timber framed buildings? We saw, as you told us earlier, that one of the reasons you didn't want to do an option 1, so to speak, in 2006 was because of the need to preserve timber framed buildings. Why had that now become something that was less of a concern?
It's the same answer to the one I've just given you, is that somebody would look at the BCA guidance and say, well, does this apply to my structure? And that was something they'd need to go back to the building control body and say, look, does this apply to my structure? And the building control body would need to have a look and see what the actual form of construction was and take a view on it. I'd rather we had more detailed guidance available, but that was the best we could do at the time.
All right, let me try this differently. It's my fault, I'm sure, for not asking it clearly enough. In 2006, as you told us, and we saw from the 18th of January 2005 email, that if you tightened up 12.7 in the way you had, it would catch timber frame buildings, and you didn't want to do that.
Yes.
I think you would accept that option 1 in the BCA guidance in 2014, 9 years later, does catch or exclude timber frame buildings.
It would do if you followed it, yes.
It would do if you followed it, yes. So why was it acceptable in 2014 to ban timber frame buildings if you followed the BCA guidance, whereas it hadn't been acceptable to do so when it came to the statutory guidance 9 years before? What had changed?
Nothing. I think I've answered this question 3 or 4 times now.
Well, I'm sorry, I apologise for repeating it, but it's my fault, I'm sure, for not understanding the answer.
Perhaps it's mine for not understanding the point you're making. The way I looked at it is you would have a starting point which was perhaps more onerous than we'd intended, but it sort of shifted, for want of a better term, it shifted the balance of power to the building control body to say, look, this is what the Building Control Alliance guidance note is saying. What's your approach to complying with requirement B4 with that in mind? And that would result in the people designing the building giving this due consideration.
Let's go to your response to this email at page 2. The foot of page 2, we can see that you come back to Mr. Evans the next day, 16th of June, 2015, and you say this: "Hi, Steve. I can't offer a formal view as such. Specific projects are a matter for the relevant building control body." Now, why did you say you couldn't offer a formal view as such?
that's the nature of the position we were in. We weren't allowed to give an official sort of. As an individual official, I can't issue categorical guidance as to what does or doesn't comply. The decision on whether something complies or not rests with the building control body. I think you've asked nearly all of my ex-colleagues the same question. That's what we were always told to be very cautious of when we were talking to building control bodies and other people in the industry, is that whilst trying to be helpful, we couldn't directly tell people what did or didn't comply.
Would that not then make it even more important for the department to put out an official announcement, that which wouldn't be individual officials offering their own opinions, which you were cautioned against, but the department producing government's statement?
That would have been desirable. This is 16th of June, so it's immediately after a general election. It would have been months before I could have done anything then. At that time, I thought we were about to update approved document B. So this was clearly something I'd need to address then.
Right.
But in the meantime, I was being as helpful as I could and trying to support NHBC.
But what Steve Evans was doing was asking for the department's position on the meaning and scope of its own guidance. Yes?
Yes, people often ask for that, and we were always told to be very cautious in the way that we did that, and that's why I've used that introductory text. As I say, I think you've asked this question to most of my colleagues, and you got the same answer. That's something that we were always told to do.
Well, that's a matter for us to decide what we've got by way of evidence. I'm asking you for your recollection. You can't offer a formal view as such. What kind of view could you offer, if not a formal view as such?
So what I'm saying is, what I can't give is something which has some kind of status beyond a bit of advice from an official in the department.
And then you say specific projects are a matter for the relevant building control body. Why did you say that?
For the same reason, we were always warned against making a decision about a project when that duty rested with the building control body.
But you remember, because I showed you that in January 2013, you had not only advised Daniel Turner of Ipswich Borough Building Control about compliance of specific Kingspan product on a specific project, but had gone so far as to give him some advice, oblique though it was, that it would be better to use a different product. Do you remember I showed you that? Yes,
I saw that, and I thought to myself at the time I'd let slip and not followed the rules that we were meant to. I imagine I've probably done that a few times over the years, but no doubt because I was aware that this particular email was definitely going to be used by NHBC in conversation with the developer. I needed to be cautious about the words I used.
It's right, I think, though, that Mr. Evans isn't actually asking you about any specific project, is he?
Not in this email, he isn't, but I think it did relate to a specific project, but I could be wrong.
And in fact, if we look at your response, if we go back to it, please, isn't that the reason? We go back to page. Yes, thank you very much. A third of the way down page 3. If you look at the last sentence, you ask him, you say, do you have some examples of specific constructions you've come across? Why did you ask him that question?
I think I was just trying to be helpful, trying to understand if there was something new.
And it's clear, isn't it, that he's not asking you in the email about a specific project, and it is for that reason, isn't it, that you ask him to give you some examples of specific constructions?
I'm not sure if I understand the question. This just seems, it doesn't seem like an unreasonable question to ask him.
Now, this query was effectively, wasn't it, the same query that Tony Baker had raised with you in November 2013 that we looked at on, I think, Tuesday morning?
Yes.
Yes. And looking at your answer, I'll show it all to you before I ask the question. If we go, I think you can start at the top of page 3. As you say, the overarching objective is that the external envelope of a building should not provide a medium for fire spread. And this is particularly important for a block of flats. People do sometimes try to play games with definitions, and where this happens, one should refer back to this objective. We came across one incident where an EPS foam was used to fill a void behind some aluminium sheeting. Because it was not included specifically for its thermal properties, the designers had concluded that it wasn't insulation and thus its use was okay. When it caught fire, the flames could be seen across the city. That's why the reference to fillers, etc. was included in the AD text. Do you have some examples of specific constructions you've come across? Maybe we could revise the text again, or maybe test some of it. Now, why didn't you just tell Mr. Evans that 12.7 didn't extend, by way of answering his question, and indeed Tony Baker's question, why didn't you tell him that 12.7 didn't extend to the external facings, but Technical Guidance Note 18 did, and therefore, under his own guidance, the question was answered?
I'm not sure why I didn't refer to the Building Control Alliance guidance note. That would have been a useful thing to do. I think the points he'd made in his email I was supportive of, and the point I'm making here is that you need to think about the objective. When in doubt, go back to the objective of the regulations.
But why didn't you just give him an answer, which is, under ADB, you can still have a Class 0 surface spread of flame because of diagram 40 and 12.6, but under your guidance you can't. I mean, it's very simple, isn't it?
I didn't think about it at the time. I think, as I said to you before, sometimes you assume that I spend my whole life just thinking about cladding systems and diagram 40. That wasn't the case. I was working on lots of different things.
Well,
and perhaps it didn't come to mind, for which I'm sorry, but that's...
Let's just take this carefully. You've received this email in the afternoon of the 15th of June, and it's a long, and I think you would agree with me, a well-crafted email on which it appears that Mr. Evans had taken some care. Yes? I mean, that's a...
It looks that way, yes.
It looks that way. I mean, it's a value judgment. I'm just inviting you to agree with it. And you didn't respond immediately. You left it a day and went back to him the following morning. And we've read together what you say there. Can you just help me? What message were you seeking to impart in answer to his question?
I think I'm just agreeing that they should focus on the objective of the regulations.
How would a developer, the difficult developer that you tell us lay behind all these questions, what did you intend that difficult developer to take away from your message at the top of page 3 there?
That you shouldn't just focus on the words in the approved document. You should take responsibility and consider the objective of the regulations.
Well, what did you mean then, what did you intend by telling the little story about the edge and using that as the reason why the reference to filler, etc., was included in the AD text? What was the point you were making there?
the point that if you don't consider the objective, you can do something which you think meets the words in the approved document, but clearly doesn't meet the objective.
And what did you mean in the last paragraph there by, after asking for specific examples, it may be that we could revise the text again or test some of it? What were you seeking to, what message were you telling the difficult developer there who would read this message?
That wasn't for the developer, that was clearly to me just asking Mr. Evans what was going, if
Right. And what did you mean by revise the text? Was that revise the text of ADB?
ADB, yes.
And what did you have in mind by suggesting a revision? To bring it in line with option 1 or what?
Well, this doesn't include a proposal, does it? I'm just saying, I'm probably because I knew that I was about to start review of ADB, I was probably asking him if there was something we should take account of in drafting it.
Now, just help us. What was the answer to Mr. Evans's question in the final paragraph? Would a cladding finish with a Class 0 rating, but which was not a material of limited combustibility, meet the guidance in approved document B?
As I've said before, my view is that if it was a solid panel, a homogeneous panel that was Class 0, then it would, in my view, meet the objective. But if it was something which had layers in it, such as a composite panel, then you ought to consider the core of that panel.
So in June 2015, just so I'm clear about this, did the limited combustibility criteria in 12.7 apply to the whole of an external cladding panel, including any finish, or not? I think not is the answer, isn't it?
Yes, it's the same answer I've given.
Before you sent this answer to Mr. Evans' email on the 16th of June, had you shared his email or discussed any part of it with anybody in the department?
No.
Why is that?
It's a routine email, and certainly at that time there was no one else in the team that had any interest in fire safety. So I'm not sure there's anyone I could have shared it with that would have helped much.
If you go back to the email, please, at the top of the screen, you say there, the overarching objective is that the external envelope of a building should not provide a medium for fire spread, and this is particularly important for a block of flats. People do sometimes try to play games with definitions, and where this happens, one should refer back to the objective. What people had sometimes tried to, as you put it, play games with definitions? What were you referring to?
My experience as a building control officer is people play games with definitions.
But the overarching objective, as you describe it, is in fact the section that Evans had quoted to you from paragraph 12.5, isn't it?
Yes.
Yes. And that particular section is simply a reiteration of the principle. Yes?
Yes.
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 And we've covered that before. The outcome which the functional requirement in B4 is intended to achieve is reflected in 12.5, isn't it?
Yes, that's the objective.
Yes. But that's not the guidance as to how to achieve the objective. It's the end point that you have to arrive at, isn't it?
Yes, I think that's the point I'm trying to make in that first paragraph, is that that's the thing that you should have in your head when you're looking at a particular aspect of the design of a building.
Well, indeed. And my question to you is, do you accept that simply referring back to the objective, the end point, the outcome, was no answer to Mr. Evans' specific question as to the meaning of how to get there and the interaction of these parts of the approved document, is it?
I think it's demonstrated that he knew how to do that, and just I was trying to be supportive in saying that you should focus on the objective. So if that's what he's doing, that's a good thing.
Well,
he's right.
I'm just trying to understand this. I know this sounds a little simplistic, but you understood, I think, at the time that there was a difference between the destination, which is satisfying the functional requirement on the one hand, and the routes to the destination. Yes?
Yes.
And what you're being asked about is, what is the route to the destination, not what is the destination. Yes?
And the point I'm making is if there's any uncertainty about the route to the destination, ask yourself from first principles, do you think you're getting to the destination? That's the point I think I've tried to make for the last week.
Well, I mean, that's in great respect circular, isn't it? It's like saying there are two routes to London, the A21 and the A23. I'd like to understand the difference between them. And you don't answer that question by saying, well, you've got to end up in London. And it's a simple
I'm not sure if that analogy follows.
All right. What definitions did you mean that people sometimes try to play games with?
My time as a building control officer and my experience of building regulations is that it's across the board of building regulations is you often get problems with designers that are trying to do something that the regulations are designed to stop them doing. Building control officers often find people throwing, trying to play games with the language rather than focusing on designing a safe building.
What language in approved document B 12.7 did you think people were playing games with?
People play games with nearly all of it, from my experience.
But had you come across instances of people playing games with the word filler or filler material or the word etc.?
Not personally, because I hadn't been a building control officer since that text had been drafted.
And indeed, I think, would you accept that it was the very lack of a definition of the word filler or filler material that had led to the problem in the first place?
Possibly, but you could well have found we'd have written a definition and people have played games with that. That's the problem with definitions.
Let's go to looking at paragraph 3, which I've read to you, which is the Edge story. I should ask you, first of all, I'm assuming you're referring to the Edge incident in that paragraph. Yes. Where had you learnt these facts about the Edge? What had you read about it? To be clear, just to help you, I showed you, I think, two reports about the Edge fire, and then the NHBC filler response to the consultation. Where had you got, just to remind you of those things, but where had you got this text from about what had happened at the Edge?
Well, this was from memory, and it's incorrect, I think. My memory is that the designers had actually considered that the core of the sandwich panels that had been used on the Edge wasn't insulation, when I think, in fact, it was conjecture on behalf of my colleagues at the time at BRE that could have been what happened. Did
you receive a response from Mr. Evans to your responsive email to him?
I don't know.
Did you follow it up with him?
I doubt it.
Why do you doubt it? I mean, you didn't, I don't think. We don't have a record of it, but...
Right.
Right.
As I say, we get dozens of emails like this, and you try and be as helpful as you can. But, I think from the time I started in the department, I remember, I think the head of division at the time, I think, was Shona Dunn, and the team had shrunk quite considerably over the years, and she was concerned that the team was spending too much time assisting people with general inquiries, and so we've been encouraged to spend less time on general inquiries and focus more of our time on the project work that we were doing. So I think that had become the way. So we were, as a matter of routine, tended not to put a lot of time and effort into dealing with general inquiries like this.
Now let's go up the chain to page 3. What's going on? Sorry, I'm so sorry. Forgive me. Yes, I'm so sorry. It's page 2. I apologise. Page 2. And you can see that Steve Evans sends the email that you sent him to John Lewis on the 17th of June. He says, John, not a very clear answer. Indeed, not an answer at all. Regards, Steve Evans. You see that?
Yes.
And then if you go up to the top, John Lewis at the bottom of page 1 says, yes, a clearer answer would have helped. And then he interprets the response. Are you surprised to hear that the NHBC considered your response to be unsatisfactory?
Yes, I mean, I knew them quite well. They could have contacted me and, if they wanted. I mean, my email asks them some questions, so I'm clearly inviting them to come back to me if they felt it was necessary. So I'm surprised they didn't do that.
Well, why are you surprised they didn't do that, given that this was your non-formal steer?
Well, I'm surprised they didn't do that, given the email I'm now looking at from John Lewis and Mr. Evans.
Well, why are you surprised, given that it was, as you've told us, your position not as an official to offer any view about the meaning of or content of ADB?
I've invited them to reply, and they've chosen not to, despite the fact that they're not happy with the reply. But looking at this, they've decided to do something else.
I mean, Mr. Evans is right, isn't he? In fact, this isn't an answer at all. It's just a lot of rather vague, story-based experiences.
It's an indirect answer because, as I say, that's what we were encouraged to use where we could. As we weren't meant to be telling building control bodies what to do, not directly. I think that, looking back at that email, it's probably more unhelpful than I think I would have intended. But these are capable people. If they wanted more help, they could have asked for it.
I think it's right that after June 2015, you had no further contact with Steve Evans or John Lewis in relation to this query or the specific subject of the meaning of the guidance in 12.7.
I think that's right.
Let's move on then to the second edition, issue 1, as it's called, of BCA Technical Guidance Note 18 in June 2015, which I think you deal with in your statement. Can we turn to that, please, at page 47? Paragraph 134. And what you say in paragraph 134, it's quite long because it goes over the page, but can we summarise it? You say that the note was issued in June 2015 and included option 4, which was the holistic fire engineering approach. Yes? And if we turn the page, I think you can see that.
Yes.
Let's do that. Yes, thank you. And you then, as you can see, set out the section of approved document beyond which the option was based. Now, you don't say anywhere in your statement whether you read Technical Guidance Note 18, Issue 1, June 2015 at the time. Did you, do you think?
I would have thought so.
Right. Do you remember when you first read it?
No.
It was sent to Richard Harrell at the time, so can we take it that it was about that time, June 2015 or so?
Probably. I don't remember.
Do you remember why it was updated?
No.
Did you not want to know?
I don't have very much recollection of it, to be honest. I think I remember seeing the fact that they'd introduced the additional option, which was fire safety engineering, which was a valid point because that's always an option.
Yeah, indeed, and it had always. I think it had been in ADB for a long time.
A long time, yes.
Yeah. But you weren't interested to know why only a year after the first edition, the second edition was coming out?
Not at the time, I don't think so, no.
Can you explain why that is, given the importance that you appear to have placed on this document the previous year in carrying a message which you were happy with but didn't feel the department could circulate itself? Why were you interested in seeing exactly what it was that had changed?
My recollection is the only fundamental change was the introduction of the fire safety engineering option.
Right. Then let's see how we go with my questions. Can we please look at the two editions side by side? I'd like CEL 403070, please, page 2, which is the June 2014 issue 0, first edition of Technical Guidance Note 18. And at the same time, please, page 2 of NHB 402440. So on the left-hand side, or right-hand side as the case may be, CEL 403070, page 2, and NHB 402440, page 2. Not it. Right, there is a problem, I'm afraid. I don't know why that is the case. Mr. Chairman, something has gone quite seriously wrong with the reference, and I need the reference. It might be an appropriate moment to take the break.
Well, it would help you out, would it, if we gave you a bit of time now?
Yes, it would. Yes, it would, and I could speed things up, I'm sure. We've only been going for an hour, and I'm conscious of that, but I need the document, and for reasons I'm not sure I understand, I don't have the reference.
Right. Well, then we probably ought to take the break at this point. Mr. Martin, something has gone slightly wrong with Mr. Millett's references, so I think we'll give him a chance to sort it out. We'll take the break now. We'll come back, please, at 3:30, and usual orders, don't speak to anyone about your evidence or anything relating to it when you're out of the room, please. All right?
Yes, sir.
Thank you very much. Would you go with the usher then, please? Well, all right, Mr. Millett, 3:30, and hope you can sort it out in the meantime.
We will be able to. I'm sure it's my fault entirely, but thank you. I'm grateful.
3:30. Yes, Mr. Millett. Now, have you managed to solve your problem with the references?
Mr. Chairman, I have. I'm glad to say. And
Good.
we can then, I think, have the witness back. I was close, but no cigar.
Never mind. Another occasion, perhaps.
Can we please have the
Would
witness?
you bring Mr. Martin, please?
Thank you.
Good. All right, Mr. Martin.
Yes, sir.
I think Mr. Millett's got his references sorted out, so if you're ready to go on, I'll ask him to continue.
Yes, thank you very much, Mr. Chairman. Mr. Martin, what I wanted to show you was the two technical guidance notes side by side. And I'd almost succeeded, but let's try that again. Can we please have CEL 403070, page 2, and page 2 of CEL 402440 on the screen? Now, here they come. That's right. Yes, thank you. Now, can we please have page 2 of each? Right. Thank you. Now, on the left-hand side, you can see the 2014 version, which has 3 options, and on the right-hand side, the 2015 version, which has 4 options. And what I want to do is to compare and contrast a little part, please, of option 3. Now, on the left-hand side, and just after halfway down page 2, option 3 says, if no actual fire test data exists for a particular system, the client may instead submit a desktop study report from a suitable independent UCAS-accredited testing body, brackets, BRE, Chiltern Fire or Warrington Fire, stating whether, in their opinion, BR135 criteria would be met with the proposed system. Now, that was the 2014 version that you were happy with, you told us. Now, if we look at the right-hand side of the screen, under option 3, it now says, if no actual fire test data exists for a particular system, the client may instead submit a desktop study report from a suitably qualified fire specialist, stating whether, in their opinion, BR135 criteria would be met with the proposed system. The report should be supported by test data from a suitable independent UCAS-accredited testing body, BRE, Chiltern Fire or Warrington Fire. So you can see that there's a difference, can't you?
Yes.
Yes, and the difference is that the suitable independent UCAS-accredited testing body was BRE, Chiltern Fire or Warrington Fire, but that's been replaced by a suitably qualified fire specialist. So the opinion is now to come only or simply from a suitably qualified fire specialist and not from a suitable independent UCAS-accredited testing body, BRE, Chiltern Fire or Warrington Fire. Yes?
Yes.
Yes. And the reference to BRE, Chiltern Fire or Warrington Fire has now been moved down so that it only qualifies the source of the test data. Now, my question, having had rather a long run-up to it, which I apologise, is, did you notice that difference in wording of option 3 in 2015 when you saw issue 1?
And I'm aware of the change, but I can't remember precisely when I spotted it. I may have picked up on it at the time. I can't be 100% certain.
Right. Do you remember having any thoughts or questions in your own mind about what might constitute a suitably qualified fire specialist?
I recognise the problem they've got in that there isn't a convenient way of describing a person suitable for this job. So I can see why they've used that language. and probably thought that was reasonable at the time. If I did pick it up at the time, which I think I may have done, but I'm not sure.
Right. Was there any definition of a suitably qualified fire specialist, either in the building regulations or approved document B or elsewhere?
No, I mean, that's one of the challenges that you have with this is that there isn't a convenient sort of badge or certificate you can point at. In my own mind, I'd be thinking of somebody that does this, that has the right sort of familiarity with this kind of work. So most of those people at that time would have worked at one of the UCAS labs. But I was aware there's an organisation called International Fire Consultants, which had done a fair bit of assessments in lieu of tests over the years, and they had a number of people working for that organisation which had the right kind of experience. They'd had a background in fire testing and understood the way materials behaved and so on. So I suspect it might have been IFC or somebody like that that had said to them, "Hang on a minute, the way this is drafted, you're excluding us from this work," which I know had happened in the past on some other similar documents. I think the Association of Specialists, I think it was the Passive Fire Protection Federation, had for some years had a document which talked about assessments in lieu of tests, and I think they'd had the same problem in trying to identify the level of competence required to do an assessment.
What level of competence or experience did you think at the time would be required to produce a reliable and robust desktop report?
I think with any assessment, you need somebody that has a good experience of fire testing in general and the fire test in particular. And I think that's essentially what the Passive Fire Protection Federation guide says.
The accredited testing bodies, BRE, Chiltern Fire or Warrington Fire, if they'd done the tests, of course, would have, wouldn't they, the knowledge of the test itself and and what it showed.
Yes.
Yes, and particularly things like mechanical failure, which might not show up in the pass-fail.
Yes, I mean, you couldn't. If you were doing an assessment, you'd need to look at You shouldn't just be looking at a classification report. You'd need the data from the tests that you're using in your
Yes.
assessments.
So whilst that might work fine for an independent UCAS accredited testing body, BRE, Chiltern Fire or Warrington Fire, did you have any concerns at the time that that requirement had been downgraded or widened, perhaps is a better word, from to suitably qualified fire specialist in circumstances where putting your finger on who was suitably qualified was something of an uncertain endeavour?
I don't think I was concerned about it at the time. As I say, I knew it had been a topic of debate before because of the fact that there was at least one, there might have been two organisations that did this kind of work. And to be fair to them, they were competent. I mean, the issue with issuing an assessment, and it's a duty that falls on somebody as a professional, is that you should only do work you know that you're competent to do.
Yes. Now, if we go to your statement, please, page 45 of your statement, paragraph 127, you say there, and you set out option 3 in terms, and you can see that there's a footnote 83 next to Warrington Fire. If we go to the footnote at the bottom of page 45, you can see that you say this. If we scroll to it, scroll down to the page, to the bottom of the page, you say under footnote 83, BR BRE, Chiltern Fire and Warrington Fire are highly reputable, and I was pleased to see reference to them in the 2014 BCA guidance note. Now, did you notice that the 2015 BCA guidance note had removed those references and replaced them with the generic description? I think you say you might have done but can't recall.
I can't be certain. I don't. If I did pick up on it, I don't think I thought it was that significant.
Do you agree that the effect of that removal, at least, and the substitution with the words suitably qualified fire specialist in the 2015 version, in place of BRE, Chiltern and Warrington, as in the 2014 version, significantly widened the pool of potential authors of desktop studies? Did you at least spot that at the time?
I might have done. I'm sorry. I can't remember distinctly. Clearly, it does.
Yes. Now, I think you'd been told, correct me if I'm wrong, but we get this from your statement at paragraph 131, but you'd been told by Steve Evans in April 2015 that the NHBC were receiving, at that time, submissions from builders mainly following option 3. Do you remember that? I can show you your statement.
Yes, I remember.
Yes. Were you aware in 2015 or any time after that time that, according to Steve Evans, the purpose of this particular amendment to the BCA note in 2015 was specifically to increase the pool of people who could produce desktop reports, because those test houses, BRE, Chiltern Fire and Warrington Fire, had capacity problems?
I don't think I was aware of that.
Were you aware that the BRE had told NHBC in November 2014 that there was a problem, an issue dealing with the volume of option 3 requests and only 3 testing houses to deal with them, and the LABC had also had similar feedback?
No.
Were you aware of that?
No, I wasn't.
And did anybody at the BRE mention that to you?
No.
Did you have any awareness during the period between June 2014 and June 2017, the 3-year period, about how frequently option 3 desktop reports were being sought by developers or building owners or produced by so-called suitably qualified fire specialists?
No, I think it's as I said, the building regs policy team didn't have a mechanism for monitoring what was happening in the industry, so I wouldn't have known.
Have you any awareness of even roughly how many desktop reports or combined option 3 / option 4 reports were issued in that period? Do you know?
No.
Roughly? Did you ever make any inquiries?
No.
Why is that?
I wouldn't have had reason to.
Well, might you not have had reason to? I mean, wouldn't the fact that developers were, because of difficulties following the BCA guidance option 1, which was tight and tighter than ADB, have had good reason to revert to option 3 because it was easier to do in order to get a combustible insulation or other product onto a high-rise building?
No, we as I say, we didn't actively interrogate what was happening in the industry. That's not how the division was structured to operate.
No. Before June 2015, when the revision to the BCA guidance note was published, were you aware of any concerns over the quality of any desktop reports?
There was, I can't remember what point in time it was, but there was a point in time when I'd spoken to a building control officer who was concerned that some of the quality of some of these assessments wasn't as good as he thought they should be. And that's something I did eventually raise with NHBC.
When was that?
I imagine you probably know better than I do. But they asked me to speak at a seminar, and I raised it with them then.
Are you thinking of the July 2016 seminar? NHBC seminar?
Probably, yes.
Something else?
Yeah, sorry. It's a very long time period, and my memory for dates is not good at the best of times.
No, I understand. All right. Well, I only ask you because we will come back to that.
Yes.
Are you aware that Janet Murrell of Exova has told the inquiry in her witness statement that she falsified an aspect of the desktop reports published by Exova by declaring on the face of 15 of her reports that each had been peer-reviewed or approved by named Exova employees who had not in fact carried out any such review or approval, and weren't qualified to do so?
I wasn't aware of that, no.
Was there any regulation or informal oversight of the practice of Option 3 desktop assessments at any time?
No. The whole system of, if you can call it a system of classification of products, is essentially industry driven and always has been.
The practice, industry driven, as you say it was not regulated in any way, was it?
Essentially, it was self-regulated, I suppose. I think originally it was the practice of assessments was something which had developed initially amongst the test laboratories in the UK by a group they called, I think it was the Fire Test Study Group. So the fire test laboratories in the UK, they're less now than they used to be. There were probably about 5 of them. They worked together to ensure that they were applying the relevant test standards consistently, and they developed a code of practice for assessments. And I think as a result of the introduction of the Construction Products Directive, they found that difficult to do because they became part of the European test world, which was sort of regulated in a different way. So that sort of best practice guidance for assessments was handed over to the Passive Fire Protection Federation.
Right. I see.
Sorry, that's a long history, but...
No, it's helpful. Are you referring to... I'm going to show you something and just see if we can pin it down. Can we look at BCA 6070, please?
Yes, that's it.
Thank you. That dates, I think, from 2000, doesn't it?
That would make sense, yes.
When did you first become aware of the existence of this document?
Well, as I say, it used to be the Fire Test Study Group's document and then got passed on to the PFPF, so it's been around as long as I've been involved in building control, and I imagine its history is probably well back into the 1970s for all I know.
Right.
I don't know when it was first drafted.
Did you ever have a conversation with NHBC about whether the desktops coming to them through Option 3 had been assessed in accordance with this guide or any later emanation of it?
I don't think I had that conversation. I may well have presumed that.
Right. Now, before I move on, I just want to ask you about something else that Janet Murrell said in her statement. She says that you were a member of the Warrington Certification Impartiality Committee. That's what she says on page 5 in paragraph D. We can see it if you like, but that is essentially...
No, it's a fact.
What she says.
Yeah.
Right. When did you sit on that committee?
Very rarely. So the way that I inherited that from, I think Mr. Bird had that role when he was in the Part B post, and I imagine somebody's been doing that for a while. The certification companies have to meet, you've probably got the references, there's a European, an ISO standard for certification companies, and I think there are a number of different ways that they need to show UCAS that they are acting impartially, and the way Warrington was constituted, they had this sort of committee of it's a cross-section of people from industry that would talk about the different certification schemes that UCAS that Warrington were running, and I was my name was on the list. I think I probably only attended 3 or 4 meetings because they tended to clash with other things I needed to do. When I did go to them, it was a useful place to meet people from the sector.
Which period, or in which period, did you sit on that committee?
I think it was probably listed on there all the time I was in the post as policy lead for Part B, but I can't say for certain. So I didn't go to many meetings because they tended to clash with other things.
And it's called the Certification Impartiality Committee. Does that involve signing product certificates or overseeing the signing of product certificates?
No, it's specifically about the certification schemes, not specific certificates.
Were you remunerated for that role?
No.
Were you a member of any other such similar committees in other private organisations such as the BRE or Chiltern Fire or the BBA?
No, I say it's something I inherited. I think there were a couple of times when I talked about withdrawing from it that the problem is that the way Warrington certification was constituted is without the committee they couldn't operate as a certification body, and they were an important certification body in the industry, and I saw it as when I could go to the meetings, an opportunity to see what was going on by meeting other members of the sort of construction industry and learning a bit about Warrington did as a certification body. It didn't really carry any great responsibility. They present different schemes to us and talk through the approach they were taking to different schemes.
I mean, how is sitting on a committee, ironically called one entitled an impartiality committee, itself consistent with your own impartiality as one of government's public servants?
I thought it was entirely consistent with it.
How come?
Because it was helping the industry operate appropriately.
But Warrington Exova was is this right? It was not a government department or public body. It was a private organisation, wasn't it?
Yeah, I mean, the way certification bodies are constituted, they're... I can't remember the exact phraseology, but they are set up to some extent for the common good. I can't remember the exact phrasing of the terms they use, but
right.
I didn't see it as a conflict. I mean, it's certainly something I think I discussed with somebody, must have been Mr. Harrell maybe, about whether I had time to stay to be involved and whether I should withdraw. But I think Warrington had a lot of problem getting people to turn up to the meeting, so where I could, I did go. I don't think it was in conflict with my role as a public servant.
But did you ever think about the question, how is membership of an impartiality committee of only one of the major market participants, the others being BRE or Chiltern Fire or BBA or others, consistent with your obligations of the highest standards of impartiality and probity expected of a government servant? Did you ever ask yourself that question?
I didn't see there was any question of the probity about it. I think I did ask myself, is it okay to only support one of them, but the others, I think they're constituted differently and didn't have a similar group, and so it didn't cause them a problem. But if all of them had asked me to join, I think I would have had to have withdrawn from the Warrington one, and I think in the end I did withdraw from it. I can't remember now. But I didn't. There wasn't a question of probity there. It was just they needed some independent observers to review their schemes. Definitely not their certificates. We never looked at specific products.
Now, I'd like to turn to January 2016 and start with the fire at the address downtown in Dubai that happened on New Year's Eve 2015, 31st December. Now, you'll remember that the address downtown in Dubai was a 63-storey hotel, wasn't it?
I don't remember, but I remember it being a tall building, yes.
Right. Well, let's look at the correspondence that there was within the department about it. HOM 30s43106, please. And can we go to the bottom of the chain? There at the bottom of the chain, which I think if we can have it expanded would be helpful. It is an email from Bob Leadsom to you, copy to Richard Harrell on the 4th of January 2016 at 08:54 in the morning. Brian, anything we need to be aware of, / worry about for Part B? Bob, you see that?
Yes.
And your response, just up the screen, up the page at 9:19, copying in others, including Richard Harrell and Louise Upton, is as follows. Might get some questions raised, nothing new here. The fire is most likely to be similar to several others that have hit Dubai over the last couple of years. It relates to a cladding product which is a laminate of aluminium and polyethylene or similar. This stuff is very rigid and makes nice shiny buildings. Now, did you have any knowledge when you sent that email about whether or not ACM polyethylene cord panels had been installed on any high-rises in England and Wales at the time?
I didn't know that any had been installed in England, no.
Did you suspect that some might have done? Not least given the reference to them in the 2nd of July 2014 CWCT meeting minute.
I don't think so. I don't remember thinking that at the time.
Now, by January 2016 and following that meeting in July 2014, had you taken any steps to find out anything about the way in which ACM panels with a PE core might be being used in the UK, specifically England and Wales?
No.
And if we continue with your email, it says this: sadly, when it gets exposed to a fire, the aluminium melts away and exposes the polyethylene core. Whoosh. Now, the whoosh there, that's another remark or observation about, as you might have called in the past, the awesome power of such fires, which is, I think, how you described the Tamwheel Tower in Dubai in November 2012.
Yeah, I think this is obviously a shorthand for saying that the polyethylene, once it gets exposed, acts as a mechanism of fire spread. It's not a term I would have used publicly, of course.
No, but it's graphic enough and,
yes.
and certainly clear enough. Now, going back to your email, you say this: requirement B41 is designed to prevent this kind of thing. Para 12.7 says, in a building with a story 18 metres or more above ground level, any insulation product, filler material, not including gaskets, sealants and similar, used in the external wall construction should be of limited combustibility. And then you say this: the polyethylene core of the offending product would be considered as a filler material, so should not be used over 18 metres. By whom would the PE core of the offending product, as you put it, be considered, as you put it, as a filler material?
Well, by then, we'd had conversations with CWCT and the Building Control Alliance, and as far as I was aware, everyone understood that was what it was intended to mean.
So, when you say would be considered, you mean by everybody? Universally considered?
I think at that time I thought it was, yes.
Did you not, at this point, though, recall Steve Evans' lengthy email of the 15th of June 2016 and his reference in there to a difference of interpretation across the industry and his request for an opinion or steer on the meaning and scope of 12.7?
What was the date of Mr. Evans' email, sorry?
15th of June 2015.
Thank you.
6 months before.
Because it wasn't at the forefront of my mind at the time. 6 months had gone by.
Instead of pinging back 25 minutes later with your response, did you take the care to dig into your emails and look back at the earlier exchanges 6 months previous and seek to find out what question it was that Steve Evans had asked you then and your response to him?
No, I mean, 6 months worth of emails is a lot of emails. I don't know why I would have. I don't think I'd have been able to do that.
Well, would you not have been able to think, I think I had a conversation about 12.7 with somebody in the summer of last year or thereabouts, and put 12.7 into your search, or Steve Evans or NHBC into your search, and throw something up along those lines?
I suppose I could have done, but it didn't occur to me at the time.
You now, I think, had knowledge of quite a history of fires in the region. UAE 2012 and 13, you had La Crosse in 2014, you had the Torch in 2015, and now, at the end of 2015, you've got another ACMP called fire at the address, downtown Dubai. This is now a history of repeat experiences, and you're being asked about it by your boss's boss. Did you not think it worth just digging into your own emails and looking back at perhaps the correspondence you'd had with Mr. Evans or something in your own archive to see what best information you could give him?
No, clearly, I probably answered this quite quickly. And that's probably as much detail as I would normally expect Mr. Ledson to want.
Why did you answer it quite quickly?
I don't know, my boss asked me a question, so I tried to respond quickly to it. I think that's probably just, I don't think there was anything in that.
I feel bound to put this to you, Mr. Martin, but we've seen a lot of your emails in the period from 2013 where you're asked questions, particularly questions about ADB 12.7, and almost without exception, they are responses which come back within a matter of minutes and are short and don't bear the hallmarks of any consideration or any research. Now, that's a generalisation, but is it a fair generalisation of the way you worked?
I can see why you'd think that. I think most of my time would be focused on whichever project I was working on at the time. Although, to be fair, I think at this point we were in the. This is post the 2015 election, so we were struggling to get anything done at the time. So perhaps at this time I could have spent more time on it.
Now we know, and I don't want to go over old ground at all, but we know that the lack of clarity in 12.7 was brought to your attention in the minute of the 2nd of July 2014 meeting. And we know, because we've seen the lengthy email sent to you in mid-2015 from Steve Evans, that there was an unresolved controversy in the construction industry about the interpretation of 12.7. And we've also seen that you never gave him a final firm position about the government's stand on that. That's right. What had happened between the 6 months between June 2015 and early January 2016 for you to be confident that your interpretation of the word filler or filler material in 12.77 was now settled and accepted in the UK construction industry?
I guess it's because we'd had those conversations with CWCT and the Building Control Alliance, so I thought that had been disseminated through building control world, house builders through NHBC, and the CWCT were passing the message on to the cladding industry. So I thought that was a well understood point.
But you had been told by Mr. Evans in June 2015 that it wasn't a well understood point because you still had the difficult developer standing on ADB, standing on his...
I didn't take it as that at that time.
But it says so. It said so in terms. It says there is the difference of opinion across the industry. Now, as we explored before, if Mr. Evans was telling you the truth about that, then there'd been nothing, had there, to have occurred between the June of 2015 and the early January of 2016 to resolve that industrial controversy, so that a universal understanding of the word filler was now held by the industry.
No, I think I probably should have said to Mr. Leadsom that there's some disagreement over this, and I regret that I didn't do so.
But why didn't you do that?
I don't know.
Moving up the chain, we can see, if we go up, that Louise Upton then emails you. Can we please scroll up to the top? She says, "Thanks, Brian, but from the news reports, 4 news reports I think it is, I heard it seems there was no fire detection, stroke alarms or sprinklers fitted or working. Could that be right? The fitted rather than the working bit will pop up when you are in." And your reply, if you scroll up further than that, which is the top email in the chain, "I'm in," and this is 3 minutes later, "I'm in. I heard bad things from people about the quality of maintenance in these buildings in Dubai. Big buildings need to be looked after properly. It might be that the sprinklers were overrun. If the cladding was on fire, then the sprinklers wouldn't be able to get at it. You'd then get multiple secondary fires all over the building. The sprinklers can only handle one fire at a time, so game over. B. What does the quality of maintenance have to do with the straightforward and clear risk posed by the installation of polyethylene cord aluminium composite material on the outside of a tall building?
She's asking me about the fire detection and sprinkler system and whether they were working or not. And that's the point I'm making, is that I'd spoken to some UK engineers that had done some work in the UAE, and they'd experienced problems with maintenance of fire protection systems over there. Right. And I'm just relaying it's rumour and hearsay. It's not a fact. Yeah. And that's why I'm saying it might not be that there were no sprinklers or the sprinklers weren't maintained. It might be that the sprinklers have been overrun, and then I describe what it's a term that's used in the sprinkler world to describe a fire which gets bigger than the sprinkler system can handle before the sprinkler system is able to control it.
Does one take from this exchange between you and Miss Upton a rather more fundamental point, which is that if you are going to use aluminium PE core panels on a tall building at all, then you are going to have a very serious and well-organised set of redundancies, fire protection and prevention measures, so that if there is such a fire, people can escape easily, and there is no loss of life or personal injury or injury to property.
You might argue that. I don't think that's what these emails are saying. We're just talking about the fact that there was a fire, and in a news report, which is probably inaccurate, news reports of fires are usually inaccurate, that suggested that there was no fire suppression system, which would be unlikely. In Dubai, that most of the high-rise buildings do have fire suppression systems in them.
I think we can take it that at the time of this exchange, you hadn't brought the existence of the lack of clarity in 12.7 to the attention of either Richard Harrell or Bob Leadsom. And you didn't do so here either, as we can see. No,
I think Mr. Harrell and I discussed, I think as we spoke about, I think yesterday, Mr. Harrell had, or was that early this morning? Sorry, it's difficult to remember when I was giving evidence. But I think it might have been another fire in the UAE where Mr. Harrell had asked me about this and reviewed the guidance for himself.
You didn't, I think you've accepted this, but just to say that we're completely clear, at this time go to either of them and say, you should know that there is this enduring, nagging controversy out there in the industry, in some quarters, about what 12.7 means and whether or not it extends to the core of a rain screen panel.
No, I didn't.
No. Why did you keep that to yourself and not escalate it?
I don't know. I think I should have done.
Yes, but is there? Can you help us? What the reason was why you didn't?
I know in particular Mr. Harrell was under a lot of pressure at that time. That might have been the reason, but I'm guessing.
What about Mr. Lenson?
I think they were both, to some extent, they were having a lot of difficulties trying to bring the building regs work programme forward with the new government. So I think they were quite distracted at the time. That might be why I didn't bother them with it. But I'm guessing. I can't remember what was going through my mind on that day.
Let's move further forward into the month of January 2016. I want to ask you now about a conference which was hosted by Siderise and the BRE on the 13th of January 2016, which was entitled Facades to Tall Buildings, Routes to Compliance. Now, correct me if I'm wrong about this, but I think you did not attend that conference.
That's correct.
Did you know anything about it at the time?
No.
So you weren't aware it was taking place?
No.
Do you know whether any other official from the department attended? We don't have any.
Very much doubt it. If it was about fire, there was no one else in the department that worked on that.
Right, thank you. Now, there was a Q&A session during the conference, and the inquiry has seen some evidence about that, and in particular that a gentleman called Nick Jenkins of Booth Muri, or Euroclad, I think it's the one and the same at the time, expressed grave concern about the use of ACM panels, and in particular ACM panels with a polyethylene core at that conference. And he told the panel, the conference panel, that is, having referred to an ambiguity that in 15 years of fabricating aluminium composite material panels for supply into the UK market, his company had only supplied 2 projects with A2 grade panels. Did you know that?
No.
Now, I'm going to show you a little bit of what happened at this conference. Can we please go to the transcript at INQ 301499? And I appreciate that you weren't there, so I'm not going to ask you questions on the footing that you were, but I want to show you what's being said. INQ 301499, page 11, please. And he says, I think we probably need the foot of page 10. If we can go to foot of page 10. Yes. He says, halfway down the screen, I think there's a lot of ambiguity at the moment as to what is acceptable as being non-combustible, and does the B classification S1D0 sit within the required or the limits of what is considered of limited combustibility, or does it have to be A2? If it's of A2, then it's of a concern, because in the past 15 years we've only supplied 2 projects where the A2 grade material has been used. So we talk about substitution of materials. There's a real concern there that actually perhaps none of the materials supplied in the UK, with the exception of 2 projects, to my knowledge, actually meet the requirements of the definition of limited combustibility. Now then, the chair of the panel if we go to page 12, we can see that he directs a question. He no, I'm sorry, we're going to need, I think, page 13 for this. Yes, and if you go to page 11, stick on page 11, you have a question from Stephen Howard, if we go to the top of page 11. So your question, right, the question is whether a Euro Class B is limited combustibility. Yeah, a BS1 D0. That's not limited combustibility. And Nick says, in which case you only have 2 projects. And Stephen Howard says, the other thing to remember is that approved document B is not the regulation. Approved document B is guidance, and there are other means to demonstrate compliance with the building regs other than approved document B. But what I would say is if you take approved document B as the absolute requirement, which I've caveated, then it's limited combustibility for buildings with a story above 18 metres. And then Andrew Kay asks a question. If you look at that, he says this, in view of what the gentleman was outlining there, does the panel feel that potentially we are sitting on a time bomb, as well as in terms of some of the materials that are installed, or do we have a level of confidence that the ones that have been installed in the past will perform in a fire? Anyone want to come back on that one? See that?
Yes.
Now, did you know that question, the question posed by Andrew Kay, the chair of the panel, was a question the cladding industry was asking itself at the time?
No.
How come you didn't know that question was being asked within the industry?
We didn't have a mechanism to know what was going on in the industry unless somebody raised something with us. That's what's clearly the fundamental gap in the way the system was constructed. So I didn't know that.
And would you accept that if there was this uncertainty or controversy within the industry, then that made or rendered the guidance documents extremely unstable?
I'm not sure if I understand what you mean, sorry.
Well, Andrew Kay puts it on the basis that there's a question at least. Does the panel feel that potentially we are sitting on a time bomb? Was that not a critical question for government to know that was being asked?
Yes, it's clearly a critical point, yes.
And therefore essential, surely, for government to have some means of being able to at least know was being asked.
But I don't disagree that government should know. I think, that's as I say, that's the 1984 Building Act was designed to minimise government intervention. Our division had shrunk considerably over the years because they didn't want us to interfere with the industry. That's why we didn't have any mechanism to know what was going on unless someone brought it to our attention. And even then we had quite limited options to do something about it.
And then if you go back to the transcript of page 12, you can see Steve Evans. You'd have to ask our builder customers, taking that, the polyethylene type panel, obviously if the building doesn't have a habitable floor over 18 metres, there's no restriction on that. Nick, I understand that, but I could name tens of projects that have, and then there's over-speaking by Steve Evans, but over 18 metres. There's an anomaly in the approved document. If you follow the guidance within the approved documents, you are deemed to have met the performance criteria, okay? So, the approved documents, if you follow the elemental method, if you use a non-combustible insulation material and your external cladding meets diagram 40, which is a class 0 surface spread of flame, you're deemed to have complied. Just pausing there, is that right?
It's not entirely right, but it's a shorthand way of explaining what the point he's making.
Well, it's a dangerously inaccurate shorthand,
yes.
Isn't it? Because it conflates compliance with, or following the linear route, with compliance with the functional requirements,
yes,
isn't it?
It does.
Did you understand at the time that people as senior in the industry, NHBC, Steve Evans, were using this dangerous shorthand, conflating following the linear route in approved document B with meeting the functional requirement.
No.
And he goes on, so there could be instances, where we have this polythene-filled panel on buildings over 18 metres. Now, just pausing there, how come? If people had understood your filler to mean core, how come?
Well, I think we all know that clearly that's what was happening, but that's not something that we understood at the time.
And he goes on, but when we talk to DC, we have highlighted this with DCLG, and they're looking at Part B at the moment in terms of looking at other areas of the regulations they need to examine, and Part B is one of those. And then he says this, we've submitted evidence to say, well, actually, turn the page, this is something we found as the building control industry. Now, just pausing there, is that correct?
Not sure about the phrase "we've submitted evidence." I guess he's talking about the conversations that we've had that we've been talking around today.
Yeah.
I don't think there was an evidence document per se that I'm aware of.
Right, so he isn't correct that he submitted evidence to the DCLG. When he says, well, actually, this is something we found as the building control industry, we've seen his 15th of June 2015 email. Is there anything else beyond that question that he had asked you about or brought to your attention?
Not that I'm aware of, no.
Let me read on. When you talk to them, it's, yes, you've got a combustible, what could be a combustible cladding, external cladding, but if you then couple that with a combustible or insulation material which is not a material with limited combustibility, actually you're increasing the risk as well. Is that, I mean, I know you weren't there and these aren't your words, but how are we to understand what he's talking about if you are the person he talked to about this problem?
I know it's not very clear, is it?
And he then goes on, well, let me ask you this. Was the NHBC in conversation with the department about Part B in or shortly before January 2016?
Not that I'm aware of. And if it was about fire, there wasn't anyone else. So.
Right. Then if you scroll down to the foot of 13, Nick Jenkins says, so to be clear, if you have a non-combustible insulation, a mineral wool insulation of one brand or another, in conjunction with a classification of external cladding that has a class 0 surface spread of fire, that's acceptable under the current regulations, ? It's a question. And Steve Evans says this, it would meet the building regulations, but as your building control body, I would perhaps be talking to you in light of my knowledge, because my knowledge is not too bad. Yeah, minimum levels of compliance with building regulations, but we as an industry should be talking to our customers about that as well, and we should be talking to government about that. And Nick then says, yeah, my personal view is that certainly should change, because you could have exactly, in that scenario, you could have an exact repeat of the Dubai fire in any number of buildings we supply products to in London. And to boot, many of those will also have a foam-based thermal insulation. Now, were you aware that it was still the view of NHBC in January 2016 that there was an anomaly in the approved document on this matter?
No, I thought that they were applying the approved document in the way we intended.
Right.
If anything, I thought they were applying the Building Control Alliance guidance note, so they were applying it more onerously than we intended.
Yes, indeed.
Yes.
Do you accept, looking at what I've shown you, that the exchange here at this conference exposes in stark terms the danger posed by the long-running ambiguity or lack of clarity in the relevant guidance,
Yes.
which you had failed to resolve despite more than 2 years of discussion about it?
Yes.
And in January 2016, we have a senior employee of England's largest provider of approved inspectors telling a room of delegates at a specialist conference that the use of ACMPE core panels on high-rise buildings complied with the building regulations. Yes?
Yes, I don't understand that given what had been done with the Building Control Alliance guidance note. I don't understand why he's approaching it that way.
Well, it comes to this question. Why didn't you tell Mr. Evans, when he asked you about it in June 2015, that the correct interpretation of the guidance in 12.7 of approved document B, by dint of the word filler, was that the use of ACM PE over 18 metres was effectively banned?
I think I was just trying to give him an answer that was in line with the way the department liked us to give answers, but I don't think it was a very good answer looking back at it. So I don't understand why he's not just why they're not talking about the Building Control Alliance guidance note at this point.
Do you accept that whatever guidance of one kind or another was produced by industry, clarification, clear words as to the intended meaning and scope of the guidance in 12.7 could only have been provided by government, and that's the department, and in the department that was you as the owner and indeed author of 12.7. Do you accept that?
I was one of the authors of 12.7.
Yes, the other didn't work there anymore. Do you accept that?
Yeah, and at the time I was desperately trying to get work moving so that we could revise approved document B.
Do you accept that as part of your job, as Bob Ledson told us, was what he called horizon scanning, namely to ensure that government was aware of what was happening out there in industry, on the horizon, so far at least as the building regulations and approved documents were concerned?
Insofar as was is possible, given that we had no resources to do so, so we could only do that where the opportunity arose.
But you didn't need resources because you had the question, you knew what the answer was, it's just you just chose not to provide it.
No, the answer was in the Building Control Alliance guidance note.
That's not a government document, though, is it, as we've established?
No, because I didn't have an opportunity to produce a government guidance note, a guidance document, and that's what I was trying to get started at this time. And it was impossible to get anything done at that point in government. It was ridiculous.
Do you accept that you should have known that there were voices, such as those belonging to Nick Jenkins, expressing the view that the Dubai fires could certainly happen here in the UK, a view which NHBC did not dispute?
I think I wish I'd had a better understanding of that and the hazard that it presented, which I don't think I fully understood.
Now, let's moving on to the next month in 2016. We've already looked at the questions posed by Nick Jenkins to the panel at the Facades Conference. I now want to turn to the emails between you and Mr. Jenkins in February 2016. Now, you deal with this correspondence in your statement, but I want to turn to the emails first from Mr. Jenkins, and we find those at CLG 4031093. Mr. Chairman, I should just say I'm quietly taking advantage of the extra 15 minutes to run until 4:45, if that's acceptable.
That was what was intended.
It was.
So
Yeah, very good. Now, if we turn in this email run, please, to page 5. We can see towards the top of page 5 an email sent by Nick Jenkins to you on the 16th of February at 1:36 p.m. Do you see that?
Yes.
Yes, and he says, "Hi Brian, I'm forwarding this query to you as recommended by Sarah Colwell of the BRE. As you will note from the correspondence below, Sarah advises the DCLG of the body with responsibility for ADB2. This matter is currently the topic of much discussion in the construction industry, and if one thing is evident, that there is much confusion and misunderstanding, your soonest review of the matter would therefore be most welcome. I look forward to hearing back from you with some clarification." Now, it's important that I show you what lies below this, because there's a long run up to it. And if we go to page 10, what we see is the start of this email run on the 20th of January 2016, when Nick Jenkins writes to Sarah Colwell at the BRE. You see that? Now, it's a long email, but I need to show it to you. He says this: "I hope this finds you well. We haven't met. However, I understand you might be the best person to help me with some clarification I'm seeking in relation to my understanding of the current UK regulations as they apply to wall constructions for buildings over 18 metres featuring rain screen panels formed from ACMs. Last week I attended a CIDERI/BRE facades conference on the topic of fire safety. During the day I asked some questions of the panel relating to the permissible use of rain screen cladding panels formed from various grades of ACM, aluminium composite materials, when used as part of multi-layered wall systems for buildings over 18 metres. There was some ambiguity in the answers provided by the panel. I believe this ambiguity stems from some people making the assumption that in the absence of BS 8414 Part 2 2005 test evidence, or a fire engineering analysis of walls featuring ACM rain screen panels, that compliance can be achieved for such wall systems by either, in bold, 1, meeting the guidance given in paragraphs 12.6 to 12.9 of ADB2 by restricting insulation product, filler material, not including gaskets, sealants and similar, etc., used in the external wall construction, to materials defined as being of limited combustibility as defined in Table A7, or providing cladding in accordance with diagram 40 of ADB2, this stipulating that if a boundary exists less than 1,000 millimetres away and or the building has a height of over 18 metres, then a cladding material meeting Class 0 national class or BS3D2 or better European class is required. In my understanding, compliance is not achieved, he says, but via an if either one or two are satisfied scenario, rather only via an if one and two are both satisfied scenario. I think this is illogical, especially following the recent evidence of fire spreading up the facade of a number of buildings in the Middle East with combustible cladding panels. A simple read through the approved document, however, would not tell you this. And when he says illogical, he means logical, not illogical, just for those listening. If my understanding is correct, and the scope of 12.7 extends to also include the external cladding, and the 3mm thick core is associated with 4mm ACM is to be considered a filler material, then, as far as I'm aware, the only ACMs available to the UK market that meet the ADB2 definition of being materials of limited combustibility are Alpolic A2 and Alucobond A2. Both of these products are classified as A2 S1 D0 in accordance with BS EN 13501 Part 1 2007. In our experience of supplying fabricated ACM rain screen panels to specialist cladding contractors in the UK market, we are rarely asked to provide such A2 rated ACM materials. The vast majority of ACM panels we are asked to provide for architectural application are either Alucobond Plus, Alpolic FR or Larsen FR products, all of which are classified as BS1 D0 in accordance with BS EN 13501 2007, and whilst they can be classified as products that are hard to burn, are not accepted as being of limited combustibility in accordance with Table A7, Appendix A of ADB2. In many instances, it's not even the BS1 D0 rated ACM panels we are asked to supply, but standard polyethylene core material ACM that burns quite efficiently. What's more, I'm aware of many tall residential buildings recently constructed in the UK where such panels are installed in combination with various foil-faced rigid frame thermal insulation boards, which are also not accepted by as being of limited combustibility in accordance with Table A7, Appendix A of ADB2. As a responsible supplier, Booth Muri Euroclad would like to put a guidance note out to the market written specifically on routes to compliance in relation to the use of ACM rain screen cladding panels and associated thermal insulation products used as part of multi-layered built-up wall systems. Before we publish any such guidance, we are ensuring that we have our facts straight. With that in mind, I would very much appreciate your thoughts on my understanding of the current regulations. I look forward to hearing back from you. Best regards, Nick Jenkins, Executive Director. Now, there's a lot I've read to you there, but first, I think, as we've seen, do you agree, and it's by way of comment, that this is exactly the approach that Mr. Evans of NHBC had advised in his response to Mr. Jenkins at the seminar, namely that the insulation was to be of limited combustibility, but the external cladding panels only had to achieve class 0, isn't it?
Well, he's asking the question. His view is that we should take the alternative approach.
Do you accept that a simple read through the approved document doesn't, or didn't, in 2016 tell you that external cladding panels had to be of limited combustibility? On the contrary, they were only class 0 or class B.
To my mind, it was clear that you needed to look at both provisions, but I accept that there was some debate over that. That's evident.
And he's right, isn't he, that only A2 rated panels would meet the definition of limited combustibility in the approved document?
Yes, although he says most of the material he was supplying was the FR, the fire retardant type.
Now, so that I've set out the full context before coming to the emails you got, there's a follow-up email, and if we go to page 8, halfway down page 8, he sends a further email to Sarah Colwell on the 1st of February 2016 and says, "Hi Sarah, regarding my email of 20th of Jan, I got an auto-reply." And then he says this: "I have received feedback from Steve Evans of the NHBC BCA and also David Metcalf of CWCT, who have both confirmed that they think my interpretation of the building regs in relation to the use of combustible materials in high-rise buildings is correct, i.e. to meet the requirements, paragraphs 12.6 to 12.9 and diagram 40 need to be followed." And then if we turn the page to page 9, the question still remains, however, as to which materials stroke components have to meet the requirements of paragraph 12.7. Previously, 12.7 was interpreted to mean simply the insulation had to be of limited combustibility, although this was not always adhered to. From recent meetings and discussions, the general understanding is now that the scope of 12.7 extends to also include the external cladding. The BCA guidance agrees with this. David's thoughts are that this is logical, especially following the recent evidence of fire spread up the facade of a number of buildings in the Middle East with combustible cladding panels. A simple read through the approved document, however, would not tell you this. And he's right about that, isn't he? A simple read through the approved document wouldn't tell you that, for reasons you and I have discussed at length today earlier.
Yes.
Yes. Now, when it came to the email you got, which I've shown you, did you read both of the emails which had been sent to Sarah Colwell, the one on the 20th of January and this one?
I believe so.
You did. Now, let's go to the response you get. And it's page 4, please. The response you give. I'm so sorry. And you say this. This is sent on the 16th of February, later in the afternoon. And you say this: "Hi, Nick. It's for the designer and the building control body to consider if requirement B4 has been met. ADB give guidance on this by saying that the external walls should not provide a medium for fire spread in tall buildings. It then offers 2 approaches, a set of rules or a full-scale test. In the rules, we deliberately added the word filler to address things that form part of the cladding system that are not insulation, but could provide a medium for fire spread. I think the core of an ACP panel could reasonably be considered to be a filler. So, unless the core material meets the rules, then the AD suggests a full-scale test. However, if the designer and building control body choose to do something else, then that's up to them." And then the page. I'm on the road at the moment, so drafting this from memory. Now, did it occur to you on this occasion that rather than simply responding to say, "This isn't a matter for me, I can't advise, this is up to the designer and the building control body," that you needed to think a little bit more about that, about whether or not, in the face of what Mr. Jenkins was telling you about his own supply into the market of these products, there might be a widespread problem with designers and building control organisations getting this wrong?
I think it was something I was worried about, but I tried to respond as helpfully as I could, given the constraints that we worked within.
Did you think at the time that if designers and building control bodies were interpreting the guidance incorrectly, then that wasn't a matter that they could themselves resolve? You needed government to set the record straight. Did you not think that that was the case?
Something I'd been trying to do in whichever way I could. I'd worked with the Building Control Alliance, thinking that guidance would help to resolve it, and I was desperately trying to get a review of ADB started at this time.
Well, why not go on receipt of this email to Richard Harrell or Bob Leadsom and say, we're on a ticking time bomb, or words to that effect. There's a problem I've discovered, which is that ACM PE is out there. It's in the UK built environment, and that contrary to what I thought before, there is a very real risk that a Dubai-type fire could happen here. We need to act now.
I think I underestimated the scale and the hazard of this issue, which is something I deeply regret.
Why did you say, I think the core of an ACP panel could reasonably be considered a filler?
I think I'm just using the language that I'm taking into account the fact that we weren't encouraged to be direct in the way that we interpreted the approved documents, because that was a matter for the building control body. So that was, I guess it became custom and practice to use that kind of language. But what I'm setting out is in my view, that the core of an ACP panel is filler, and that's what's going to meet the functional requirement.
I mean, did you also mean that the opposite interpretation was also reasonable, that it could reasonably be considered but to be something else?
No, I didn't mean that at all.
So why not just tell Nick Jenkins what you intended back in 2006, that the word filler covers the core, full stop, and that is clear and unambiguous, or at least if it isn't, that is how it should be read.
Yeah, as I say, we've been encouraged always to be very cautious about being direct in our advice on and our interactions with industry, and being and so we always tended to use this kind of language, and I appreciate that it appears unhelpful, but that's right. The approach we were encouraged to take.
I mean, is there a deeper truth here, that in fact one of the reasons, or the reason you didn't do so, is because you knew the word filler had not only not been defined, but that it hadn't been checked with industry at the time in 2006. It had been snuck in under the radar at the last minute, and now you realised it was controversial and had created a legacy of non-compliant, dangerously non-compliant Dubai-style buildings here in the UK.
I don't think that's what I was thinking, no.
But you were scared of pronouncing an outright ban of a PE called ACM because it would upset industry and cause a row?
No. I've already answered that question. I'm using the language that we'd been encouraged to use as officials, which is not to be direct in our advice on compliance.
But if that's right, and you felt constrained to give him this sort of mealy-mouthed argument based on reasonableness, as opposed to a direct answer to a direct question, did that not make it all the more urgent and important to get out an FAQ at the very least, so that government's position was clear, and that everybody from the NHBC senior echelons down to the jobbing architect could understand what government's position was, as opposed to leaving it to individual industry components to work it out for themselves and keep bombarding you with questions?
Yeah, I think by this point I probably would have agreed with you, but it was almost impossible to do anything in government at the time.
Is that a good point, Mr. Millett?
Yes, Mr. Chairman, it is.
Right, thank you very much. Well, Mr. Martin, it's time we drew a halt for the day. We're going to finish at that point. I'm afraid I'm going to have to ask you to come back on Monday to answer some more questions. So 10 o'clock on Monday we shall resume. Again, with the weekend intervening, it's very important that I emphasise that you shouldn't discuss your evidence or anything relating to it with anyone once you leave the room. I hope that's clear.
Yes, sir.
Hope you get a bit of a break over the weekend, and we'll look forward to seeing you on Monday morning.
Yes, sir.
All right. Thank you very much. Would you go with the usher then, please? Thank you very much, Mr. Millett. Nothing else we need deal with this afternoon, I take it?
No, Mr. Chairman, there is not. And I hope we will see you here in person at BBR on Monday morning.
Thank you. Well, I certainly hope to be back, and
I wish you well over the weekend.
thank you. I look forward to that. And right, well, we'll end there then and resume at 10 o'clock on Monday morning. Thank you very much.